Hi everyone, and welcome to JAS 423 Civil Procedure 2 Small Claims Court Quiz. Okay, so let's get to it because I'm a little pressed for time this afternoon. Happy Friday. And here we go. To make a change, what physical changes must Luna make to the claim? She must mark it as amendment and underline any additions. As per rule or subrule 12.011. Number 2, how is the amended claim served? Served the usual way: fax, mail, courier, personally by amending party, or by alternative to personal service, pursuant to rule 12.012, subrule and 8, subrule 8.0114. What is the deadline? Question number 3, what is the deadline for filing an amendment? At least 30 days before trial, unless court on motion allows for a shorter time, or a clerk's order permitting the amendment is obtained under subrule 11.2. Sorry, I just had to confirm that. Subrule 11.2.011 as per rule 12, subrule 12.013. In their amended defense, Cheap Stuff alleges that Luna is a philanthropist and a thespian and therefore has no right to bring an action in Ontario. What rule should Luna consider and why? Rule 12.02, subrule 1 and 2 can be used to strike out ridiculous defense. No reasonable defense applies to all pleadings, including the amended pleadings. Okay, so philanthropist and a thespian, so a giver of money and a performer in theater, doesn't really mean anything, and it's ridiculous and ludicrous. Okay, Rule 13, settlement conferences. Let's keep going. We've talked a lot about how things are supposed to settle, or at least that's what the courts want them to. So here we go. Question number 5. How are the time and place of settlement conference set, and how do the parties learn about the time and place? So the clerk fixes time, date, place for a settlement conference, and serve notice of settlement conference together with a list of proposed witnesses. Of course, that's got to come back. Excuse me. When Luna shows up, but Cheap Stuff does not, what's going to happen to Cheap Stuff? Well, that's going to be resolved with the help of Rule 13.02, subrule 5 and 6. Party who received the notice of settlement conference fails to attend the conference. Court may impose cost sanctions and order an additional settlement conference if failure to attend. Sorry about that. Okay, where were we? So cost sanctions. Okay, so if someone doesn't show up, then the deputy judge is everyone's gonna get a little ticked off, right? And you have to show up to these things. So the additional settlement conference may be made. If failure to attend a second time occurs, the court may strike out the defense, dismiss defendant's claim, or strike out any of that stuff. It is very serious to miss a settlement claim, so settlement conference. After the settlement conference, what does the clerk have to do? Serve an order on parties not present within 10 days after judge signs order, pursuant to Rule 13.005, subrule 5. And provide parties with notice saying if the matter is not settled within 30 days, they must request a trial date. So what are the official goals of the settlement conference? Question number 8. 13.031, the purposes of a settlement conference are to resolve the issues, narrow the issues of the action, and expedite it, encourage settlement, assist the parties, and provide full disclosure. So there's your list there. 9. During a settlement conference, that Luna admits that she was occasionally tempted to borrow money from the till Cheap Stuff says it plans to introduce her comment into evidence at trial. Is this permitted? Not without Luna's consent, pursuant to Rule 13.034. Okay, so that's a disclosure restricted. Except as otherwise provided on or with the consent of the parties, the matters discussed at the settlement conference are not to be disclosed to others until after the action has been disposed of. So these are without prejudice, right? Things are said in settlement conference that have to stay within the four corners of the settlement conference. Some settlement conference end with a memorandum. If one is prepared, what happens to it? The memorandum ends with Rule 13.061 memorandum and Rule 13.6 Subrule 2 copy to trial judge and file with court. Okay, so there we go. Question number 11. In the case Luna and Cheap Stuff drags Cheap Stuff lawyer, if the case drags on and the lawyer advises settling, when can an offer be made? So we're dealing with Rule 14 settlement. No time limit, but cost consequences don't apply if less than 7 days before trial. Okay, so you can bring an offer to settle at any time. Doesn't matter if Cheap Stuff is defendant. No. Rule 14.01 says party. Rule 13, when Luna receives an offer, she amends her claim to include Cheap Stuff's offer as evidence of their liability. Ouch. Does Rule 14 permit this? No, of course not. Okay, that sort of stuff should be just sort of making its way into your head right now. No, not at all. Rule 14.4, no disclosure to trial judge if offer to settle is not accepted. Again, so without prejudice stuff. Okay, can't be communicated. Rule 14, Luna is seriously considering the offer. How long does she have to accept it? Until withdrawn or a court makes an order. Pursuant to Rule 14.031, Subrule 1 and 2, or Rule 14.033. That is sort of, there's the time limits to them or lack thereof. Luna accepts the offer, which doesn't speak to costs. Is there any way for her to get costs now? Rule 14.044, if offer is silent as to costs, plaintiff is entitled to disbursements of the date served offer. If plaintiff offer, just disbursements. Okay, so you've got to build that in. What costs should she be entitled to? Disbursements to the date of defendant's offer or date of acceptance of the plaintiff's offer, pursuant to Rule 14.044, Subrule 4, and Clause A and B. After agreeing to the offer, Cheap Stuff doesn't pay. What happens? Simple. Rule 14.6, make a motion for order in terms of accepted offer. And question 18, if the offer is not accepted but remains offer and Luna does better at the trial, then the offer she's entitled to costs not exceeding twice if conditions of Rule 14.072 are met. Okay. All right, and just quickly the final three with motions from Rule 15. Which forms are needed to bring a motion at small claims court? They are 15 alpha, 15 Bravo, affidavit and response. Okay, so just look at those forms. How much notice is needed? 7 days, Rule 15.013A, and 21. Costs are recoverable in a motion, but what's the ordinary limit? Not exceeding $100, except in some circumstances, 15.07. Okay, that's it. I've got to go. Kept it under 10 minutes, so there you go. We'll reconvene next Monday online. Thanks very much. Have a great weekend.